This will be my ruling on the issue of the intended production by the state of the bid allegedly submitted and forming the subject matter of this trial. Is the witness outside?
Yes.
If there are any witnesses sitting in the garage, we may be able to get outside, please.
Register. Police. Oh, yeah. The state called one Isa Precious, who is on the stand giving evidence on behalf of the state. She's a procurement officer employed in the Ministry of Agriculture. And her job involves creating adverts for tenders, preparing tenders, collecting documents to the violation committee, and taking them to the procurement regulatory authority of Zimbabwe. While the witness was on the stand, the state applied to produce through the witness a document which the state said is named a bid by Blackdeck Livestock and Poultry Farming and / Blackdeck Private Limited. Procurement reference MLAFWRRHQ CB 422021 for the supply of delivery of goods for the presidential scheme. The intended production of this document has been resisted by the accused persons. Mr. Jetoro, who acts for the first accused person, objected to the production of the document for several reasons, in his own words. He said that the document was not discovered. The first accused person was not finished with the document prior to preparation of this trial. The document ought to have been discovered and served on him in terms of Section 66, subsection 6 of the Criminal Procedure and Evidence Act. He said the accused person was only finished with the bid on the 3rd of June 2025, when three witnesses had already given evidence. And the first accused person had already cross-examined the three witnesses without that document. He said the accused, that is the first accused, they requested the document prior to the trial, and he had not been served with that document. He had already examined Mr. Basera, whom he submitted was a key witness in this matter, without the benefit of, in the absence of that document. He said the state indicated that documents that it was producing which already form part of the exhibits before this court, were being plucked out of that document. He then read to this court section 66, subsection 6A, which he said enjoined the state to avail to the accused person all evidence that it is going to rely on, and that included a mention or the discovery of any documents to be used at the trial. Mr. Maduku, who represents the second accused person, also resisted, opposed the production of the bid. He also referred the court to section 66, subsection 6, paragraph A and B, and he said it is a matter of interpretation, and it goes to the issue of the right of a fair trial. The production of the document at this stage, which had not been served on the accused person, would result in an unfair trial. He said that the purpose of the Criminal Procedure and Evidence Act ought to be seen to be the protection of the accused person's right to a fair trial. He said, in terms of section 70, subsection C of the Constitution, the accused person ought to be given adequate time and facilities to prepare for the trial. He obviously meant that the absence of this document meant that the accused person was not afforded the necessary facilities that he required for this trial. He said an exhibit is evidence, and that if you do not mention that there will be a witness who is going to produce a document, then that is an omission which should, in my understanding of his submission, fatal to the production of the document. Yeah, and he said it is important for the accused person to have all relevant documents, and particularly this document was required at the time that the second accused person was preparing for his trial. He submitted that there is a real possibility that this document is now being produced to undermine evidence which has already been laid, which may be favorable to his client. Now, Mr. Stolle also weighed in on behalf of the second accused person, and he placed before this court important case law, especially the Eastview Investments Private Limited versus Osiam Jaya, Supreme Court 52 of 21, which says that the accused person has the right to be served with all the state papers and all the documentary evidence which the state intends to rely on. And the state has to discover these documents, and that a trial is not supposed to be conducted by way of ambush. All evidence to be relied upon by the state had to be disclosed to the accused person. And he submitted, obviously referring to section 382 of the Criminal Procedure and Evidence Act, that the accused person had the right to be to receive this document as part of the documents to be used for the preparation of his trial, at least 10 days before the commencement of the trial. He said that had not happened in this case, and therefore and that was the ground for objecting to the admissibility of that document. He cited the case of S versus Chibaya, which said Harare High Court 4 of 2007, which states quite clearly that even the diary, the police diary, the police record of investigations ought to be made available to the accused person, obviously upon request. And he said if the document had been placed before the accused before the commencement of the trial, then they would have taken instructions on it and they would have put questions to the witnesses. Mr. Mabaudi replied. He said that the accused persons may not approbate and reprobate. They could not approve of the document and disapprove of the document at the same time. He said the accused persons, in cross-examining the witnesses, went to great lengths in referring to the bid document. And he said that the court therefore needed to see this document in view of the extent to which it has been referred to, and for the purpose of this trial, in order to ascertain the truth, where the truth lies in this matter. He said that as soon as parts of a document have been mentioned in court, and then the court must, in the interest of justice, see the entire document. He said, in fact, the court could mero motu see that document because there's a provision in our procedure, criminal procedure, which entitles the court to use its discretion to see the document which has been referred to at a trial. And he said that the accused persons are aware of the document. That is the reason why they referred to it. If they were not aware of it, they would not have referred to it in cross-examination. He said this court has got discretion in this matter, notwithstanding that there was no due compliance with Section 382 of the Criminal Procedure and Evidence Act, in the sense that the accused persons were not served with this bid document 10 days prior to the commencement of the trial. But he said the fact that this court has got discretion is actually common cause at this trial, because when Mr. Chetoro, who represents the first accused person, was cross-examining the state witnesses, he was pulling documents from his briefcase, and those Mr. Mabaudi's words, without having given the state prior notice of those documents, and the court used this discretion to allow the use of those documents subject to the state being given adequate time to inspect those documents. Mr. Jetero then submitted that his client had requested for this bid and the state had refused to furnish it. And he said he had never seen it. And to which Mr. Mabaudi submitted that the key consideration was whether or not there is prejudice to be caused or to result from the production of that document. I reserved my ruling in this matter, and as I have said, this is my ruling. I have benefited a lot from the case law that is placed before me and from the arguments that were placed before me by the parties. I note that the bid, it is common cause at this trial that the bid which the state intends to produce was allegedly submitted in response to a tender which had been flighted by the Ministry of Agriculture. And it was according to the state, it was a bid allegedly submitted by Blacktech Livestock, Poultry and Farming. And that is the essence of the charge which the accused persons are facing. The simple allegation is that the two accused persons unlawfully made a misrepresentation to the Minister of Lands, Agriculture, Water, Fisheries and Rural Development, intending to deceive the ministry or realizing that there was that risk, and intending to cause the ministry to act upon their misrepresentation, that certain documents, tender documents submitted by Blacktech Livestock Poultry Farming were emanating from a registered company, and the documents submitted with them being a ZIMRA tax clearance certificate and a NASA compliance certificate were valid, and yet the accused persons knew that Blacktech Livestock and Poultry Farming was not a registered company in Zimbabwe, and that the tendered supporting documents, which I've already mentioned, were not authentic, and that the entity known as Blacktech Livestock and Poultry Farming was not eligible to participate in the Presidential Good Person Scheme tender. It is on that basis that I said that the bid itself, which the state produced, is allegedly is the bid that was allegedly submitted by the accused persons and forms the subject matter of this trial. Once it was produced as a bid in response to a request for tenders or bids to supply goats for the presidential scheme, and it was processed and filed and kept by the government, it then became an official document. The production of official documents is governed by sections 276 of the Criminal Procedure and Evidence Act. That must also be read with section 275. But section 276 of the Criminal Procedure and Evidence Act governs the admissibility of official production of official documents. It says any original document in the custody or under the control of any officer of the state by virtue of his office may be produced in any criminal proceedings before any court unless the minister certifies in writing that it is undesirable that such original document should be so produced. So that is the section which governs the admissibility of official documents. It is not contested at this trial that the witness who has been called by the state has introduced herself as the procurement officer who is responsible for the receipt of these documents, for processing them and keeping them. She would therefore, by mere reading of section 276, would be the witness who can properly produce this document in compliance with that, with section 276. Mr. Judicial submitted that this document cannot be produced because it was not served upon the accused person in compliance with Section 382 of the Criminal Procedure and Evidence Act. Section 382 of the Criminal Procedure and Evidence Act has got the subheading, how documents to be served. And it reads as follows: unless a specified period is expressly provided, any notice or document required to be served upon an accused person shall be served by delivering it to the accused at least 10 days before the 10-day specified period for his trial, if his trial is before the High Court. The rest it may not be necessary for me to read the rest because it then deals with other, the procedure itself of serving. I agree with the defense that the whole idea of service on the accused persons of documents prior to the commencement of the trial is to make sure that the accused person is availed with all documents of the facilities, documents involved, to enable him to adequately prepare for a trial. Mr. Judicial submitted that this document was not discovered. Although it's not a term that we normally use in criminal proceedings, he obviously referred to, in my understanding, discovery means disclosure. I do not agree with him that this document was not disclosed. It was disclosed in the sense that it is disclosed in the charge sheet. It is disclosed in the summary of the state case. It is disclosed in the summary of the evidence of the witnesses. So the accused persons were aware that this trial is all about that bid, which in fact, as I've already stated, is now an official document which is in the custody of the state. So there was the disclosure of this document. There was, of course, an omission by the state, which I believe is not really disputed, to serve the actual bundle of documents on the accused person. To understand the situation which we find ourselves in, as that, I wish to just give the background to this. The state intends to produce this document. The document is a bundle of documents allegedly submitted by black livestock, poultry farming, and for the supply of delivery of presidential goats in fulfillment of the requirements set out in the document, which is already part of the exhibits before this court. The document that I refer to is Exhibit 3, which is headed bidding document for the supply and the delivery of goods for the presidential livestock input scheme pass-on scheme, procurement reference given, Government of Zimbabwe standard bidding document for the supply and delivery of goods for the presidential livestock input scheme. This is the template which was made available to all persons interested in bidding for this tender, and it sets out its requirement. The document, which is Exhibit 3, set out the bidding procedure in Part 1, and then in Part 2, the statement of requirements thereof. In other words, the document which was allegedly submitted, which the state intends to produce as the document allegedly submitted by the entity and by the accused persons, is in compliance is the fulfillment of these requirements. In other words, it is a bundle of documents which consists of a completed bid submission sheet, a completed statement of the requirements, and copies of every and all documents necessary to demonstrate eligibility in terms of Section 28, subsection 1 of the regulations, proof of registration of the entity which is bidding in with PRAZ, the Procurement Regulatory Authority of Zimbabwe, a bid security in the format specified, and copies of the CR6, copies CR14, a certificate of incorporation, and tax clearance. And then it is also, it must also contain a statement on the payment terms, and then it had to be spiral bound. Yeah, it is the spiral bound document containing all these documents which the state now intends to produce, which the accused persons are resisting. Having considered the submissions, I came to the conclusion that this document can be produced at this stage. My reasons are that, as I have already said, this document was in fact disclosed by the state. The accused persons were aware at all times that this trial is concerned with that document, and they actually distance themselves from this document. The document is admissible in terms of the law that I have already stated, sections 276, as also read with section 275 of the Criminal Procedure and Evidence Act. It is in fact an official document it is, according to the state, it is a document which was made by the accused persons. In other words, I'm not really making the finding that it was made by the accused person, but it is the state allegation that this document was made by the accused. That is the essence of the charge, that this document, they made the misrepresentation, they submitted this document and caused the ministry to act on it. So the misrepresentation is alleged by the state to have been made by the accused persons. And I'm mindful of the provisions of section 281 of the Criminal Procedure and Evidence Act, which states that if in any criminal proceedings against any accused person, direct oral evidence of a fact which would be admissible, any statement of such fact contained in any document, whether such document purports to be original or a copy, which was made or kept by, or is proved to have been in the course of transmission to or any time the custody under the custody of that person, or an employee or agent of that person, shall be admissible as evidence of that fact against that person. This section normally refers to secondary evidence where the document is in the custody of the accused person. But the relevance of this is that it is the state's allegation which they must prove that in fact this document was made by the accused person. And so any reference to it would not really come to the accused person as a surprise. But more importantly, if one reads the charge, the essence of the charge is that certain documents, false documents, were submitted with the bid, which is now the official document. The allegedly offending copies of the allegedly offending documents have already been produced and are before this court. I therefore agree with the state that notwithstanding the non-compliance with section 382, which states how documents should be served on the accused person, the consideration at this stage by the court is the prejudice that is likely to be caused to the accused persons if the document is produced. As I've said, the document was disclosed. The accused persons used copies from the documents, from the bid itself in cross-examination. There was reference to it. The offending documents which form part of that bid have already been produced, although they were copies thereof. The accused persons have had time to study the documents, and they have had more than 10 days to study these documents before the bid, before its production in court. So if any questions arise from it, then the accused persons have had adequate time to prepare. I also agree with the state that this court has got discretion in terms of Criminal Procedure and Evidence Act, to require to inspect any document which is relevant to the fair and determination of an issue at the trial. In fact, when the third witness finished testifying, the court, the only question put to the witness was related to what the document says as to the person who submitted it. And this question cannot be answered without the court having sight of the document itself. Rather than this court declining the production of this statement at this stage, when more witnesses are yet to be called, and then waiting for its turn to exercise its discretion after the parties have closed their cases, I believe that would actually be prejudicial to the accused persons, because they will not have the opportunity to put questions on the key witnesses, on the important witnesses who are now being called, particularly the procurement officer who is on the witness stand, unless that witness is recalled. In the event that the accused persons feel that there are questions that they intend to put to the ZIMRA official who testified on behalf of ZIMRA, and to the official who testified on behalf of NASA, and perhaps to the permanent secretary, the witnesses can be called. That can be cured by that the witnesses being recalled for any questions to be put to the witnesses. There has been reference to section 66 of the Criminal Procedure and Evidence Act, and it would be remiss for me to conclude this ruling without referring to it. Section 66, subsection 6 reads as follows: where an accused person has been committed for trial in terms of subsection 2, they shall be served upon him or her, in addition to the indictment or notice of trial, a document containing a list of witnesses it is proposed to call at the trial, and the summary of the evidence which each witness will give, sufficient to inform the accused of all the material facts upon which the state relies. And a notice B, a notice requesting the accused to give an outline of his case, his or her defense, if any, to the charge, and to supply the names of any witnesses he or she proposes to call in his or her defense, together with a summary of the evidence which each witness will give, sufficient to inform the Prosecutor General of all the material facts on which he or she relies in his or her defense, and informing the accused persons in the event that that in the event that the accused person declines to give the information referred to in paragraph B, whether on the grounds that he or she wishes to exercise his right of silence or otherwise. I note that the obligations on the state and on the accused persons with regards to subsection 6 and in terms of section 66 subsection 6 are similar. The requirements of a fair trial are that the state must advise the accused person of the evidence to be led and provide him or her with a summary of such evidence. And I agree that that also involves an indication as to any documentary evidence that may be produced, or disclosure of all the evidence, so that the accused person is sufficiently informed of the facts on which the state will rely. The accused person has a similar obligation towards the state. In this particular case, it is common cause that the accused persons made an omission with regards to this, which resulted in an objection by the state to the reference and production, reference to certain documents, and it was common cause at that stage that this court could exercise its discretion with regards to the production of that documents, which it did, and gave the state adequate opportunity to peruse the documents which the accused persons intended to use in cross-examination. I have used the same discretion in this matter, and I believe that the accused persons have had adequate time to inspect this bid. And that is in addition to the fact that the bid is also alleged by the state to have originated from them, and they would have knowledge of it even prior to its submission, and therefore there would be no prejudice to result from the production of that document. As I have already indicated, my ruling is that the document is admissible and it can be produced through the witness. That's my ruling.
I didn't, my lord.
State?
Yes. If is Precious, maybe called him, officer.
Yes.
My lord, the honorable assessors, the state wish, if the witness may be
what language were you using? You can swear the witness again.
Precious Isa.
Right, Precious Isa. makadaro voti mwari mandasina.
Mwari ngavandibatsire.
The witness is now under oath.
State.
My Lord, the state wishes to produce the original copy which was submitted by Black Deck Livestock and Poultry Farming.
Have you given counsel for the defense the opportunity to go through the original to satisfy themselves that...
Yes, they were given last time, and today I saw Mr. Judicial going through it again.
Mr. Judicial?
Yes, my Lord, I confirm that I was given an opportunity to
Go through it, yes.
I, however, note that my learned colleague is saying that it is an original, yet it is transcribed that it is a copy on the face of the document.
Original copy. My apology, my Lord. It's an original copy. As the witness had explained, that there are 3 copies which are submitted, one being labeled the original, and the other 2 are labeled copies of the originals. I had made enough copies, but I gave Professor Mr. Maduku one of my copies. I think he inadvertently left the copy at his office. So if I may be allowed to produce 2 copies, then after lunch break, I'll bring the 3rd copy. I'll have it done at work. Back at the office, maybe give it.
Maduku? I understand they've been given a
No, I
replacement
think
copy.
I was not able to recall whether I was given that copy or not. So I certainly not be able to confirm. He mentioned it when we were starting, but I certainly not remember.
I think you were saved because in your submissions you said you received it, but you don't intend to read it.
Yeah, so we had not. I'm not sure whether it was an original copy, the one that we got.
Okay.
I'll bring another 3rd copy for the 3rd member after
But
adjournment.
I still am on the floor
Yes.
because we are still objecting to the production of the document on the basis that it's not an original. We have not seen the original copy. We have not perused the original copy ourselves. We certainly need an opportunity to peruse the original copy and to satisfy ourselves that it is an original copy.
Mr. Mabaudi?
I think if my learned colleague was listening to the evidence which was given by the witness and also the requirements on the bidding documents, the requirement was that each bidder was to produce 3 copies, 3 similar copies, one being labeled original, then the other 2 being labeled copies. The 3 were said to be the same, in order for one to qualify, unless my learned colleague's argument that he intends to present is that a bidder who was expected to reproduce 3 copies, the copies that were produced in the process were different, then I don't know whether that is the argument that he intends to make. But otherwise, for the purpose of this trial, any one copy of the bids which were made would suffice, because it's one and the same. It's just in a case of labeling, which is there. I don't know what difference that would make if any one of the 3 copies were to be produced, whether it would make any difference, whether there's any difference between the original copy in the labeling of the original copy and the other.
I think he wants the original.
If it was the original, I think we can adjourn now. This is the witness who can go and look for the original. Whether it can still be secured, maybe I can briefly talk to her whether we can bring the original, if it will make any difference.
Can you quickly confer?
Thank you very much. told maybe there might be a need to go and check whether the original one labeled the original can be found at the office.
But is this the document that she kept?
Yes. It was one of the 3 documents which were produced by Black Tech. But even though, in terms of Section 277, not 277, but even though maybe we may exhaust that if Professor Baduku has got any particular interest in the original.
Yes.
But if he's just doing it for the purpose of just wanting to satisfy his eyes without any specific...
maybe he thinks that document may be different from the...
I would have thought my learned colleagues would have gone through the documents that were served, confer with their clients, and then say, no, the one that has been produced, it is being questioned. But that is not the argument that they are presenting. They just want to see one labeled original. That word is the one word Mr. Maduk is interested in seeing.
Yes, let's
Don't
just...
speak for me. I think that I need to be clear what we are saying so that if we get an adjournment, we don't keep coming back to the same point. We want compliance with Section 275 for the Criminal Procedure Act. Compliance with that section is mandatory. There is no way this court can conduct the trial outside the provision. Now, in terms of that, it ought to be an original or is certified original, and there are various steps that are given in terms of that section. If there's going to be some document which is not the original, then the head of ministry must do a certification. That is 275, 276, and 277. The ruling of the court is that this document is being admitted in terms of those provisions. But those provisions are not being complied with in terms of what my learned friend wants to hand over. So we are objecting to that. And my Lord, it might be appropriate that we sort it out with him. We really want nothing but compliance with the provisions of the law.
Very well. I don't believe it is necessary for me to rule on this yet. A compliance issue is something that the bar can deal with. I don't even want to interpret the provisions because they are there for you for all of us to see. So I will allow an adjournment for the parties to discuss this issue and agree on how to comply with the order that I've given, which is that the document can be produced. The modalities, I don't have to give advice. You just have to look at the law and agree on how it should be done. So are we... Very well. We will provisionally keep the documents that have been placed before us. And while you discuss.
Thank you, my Lord.
Before we level them exhibits. Do you think you are likely to complete the process today?
My Lord, I think we won't be able to complete today. We really want to be scrupulous with that, and with our learned friend, just to go through the provisions and agree what he has to do before we can have the documents made as a...
We are supposed
We've
to proceed.
understood the ruling very clearly, and we will be able to get to it.
In that case, if it may be roll over to tomorrow, maybe, I don't know whether it's 9 will be suitable because we are losing time.
Registrar, how many appeals we have tomorrow?
We were suggesting 11.
that on Tuesdays I did. Very well. We can start at 9 o'clock on Wednesday. You will just have to excuse me briefly at 11 o'clock. I have a case management meeting, which shouldn't take too long. Then we can proceed. So we start at 9. We adjourn as usual for the tea break at 11. Is it 11 or quarter to 11? When we adjourn for tea?
Quarter to 11.
Quarter to 11.
Yes.
Then I'll make use of the tea break to manage the other case.
Yes.
And then we can proceed. So we can block the whole day on Wednesday for this trial.
Thank you. If the rest of the witnesses may be called in, they are outside.
We are making very slow progress in this trial. I would encourage the parties in future to deal with these issues before the court sits, because I really can't be making rulings at every turn. The certain things have to be managed by the lawyers. Regrettably, we won't be able to hear your evidence today. We have got a technicality which has arisen, which has affected which has brought about, which has necessitated our adjournment of this trial, so that the lawyers who represent the state and the accused persons can have a meeting and discuss the way forward without the involvement of the court. But definitely the trial will proceed after they have dealt with those housekeeping issues. So we intend to excuse you now so that you can go back to work, and so that you don't have to wait while they are addressing the issue which has arisen. So you are all excused, including Issa. You are also excused. But Issa, you will have to be here on Wednesday at 9 o'clock. I would suggest state that you probably just take
one.
No. Let's deal with Issa on Wednesday.
On Wednesday.
Yes, and then you can take note of the phone numbers of the other witnesses. These are government officials. They shouldn't be difficult to bring to court.
Normally they are cooperative.
Yes.
Not a problem.
So I hope I'm right. That as government officials, we should be able to bring you to court by mere phone calls. The law requires us to warn you and record that we have warned you, or to save papers on you. But you, as government officials, we have not experienced any problems with government officials. They normally respond to invitations. Am I right in that regard?
Yes, sir.
Yes. So I will excuse you on the understanding that the state will call you as and when you are required. We are proceeding with this trial on Wednesday. The possibility is that you will be required this week. So just be available at your places of work during the normal working hours. If it's after 5, then you know that like any other government office, we are also closed. So you won't be called after hours. So be at your places of work during working hours. So the other three witnesses, you are excused on that understanding. Issa, come back on Wednesday. Thank you. So accused persons, please.